If California can call your suppressor a mere accessory and make you a felon for owning it, what stops them from coming after your recoil pad, your optic, or anything else that makes your rifle safer and more controllable right now? In Sanchez v. Bonta, 3 judges on the Ninth Circuit are reviewing California Penal Code Section 334-2, the state's total ban on firearm suppressors, even for people who would be perfectly legal under federal NFA rules and the new One Big Beautiful Bill Act. On November 18, 2025, state lawyers stood in front of that court and argued that suppressors aren't even protected by the Second Amendment because they're not arms at all. In this video, I'm going to walk you through what those judges actually heard. How Bruen and Duncan v. Bonta shaped this fight, and what's really at stake for ordinary gun owners far beyond California's borders. Let's slow things down and walk through Sanchez v. Bonta step by step. After we finish, you would probably be able to explain this case to anybody in the range or at the dinner table without needing a law degree. We're unpacking who is actually involved, what law California is using to turn a quiet piece of metal into a felony, and we'll move into what happened inside that Ninth Circuit courtroom. On the law on the table. Gary Sanchez is not some cartel hitman in a movie. He's an ordinary American gun owner who wanted to do something that, in most of the country, is completely legal: own a suppressor after going through the federal process. The problem is California Penal Code Section 334-10. That statute doesn't regulate suppressors. It doesn't license them. It doesn't tax them. It flat out bans possession. If you have a silencer in California and you're not in a very narrow government carve-out, you are looking at a felony charge, prison time, a big fine, and the likely loss of your gun rights. Now compare that to how the rest of the system treats suppressors. At the federal level, under the old NFA rules, suppressors are tightly controlled, but they're not outlawed. You pay your taxes, you submit fingerprints and paperwork, you wait for the government to approve it, and then you can legally own one. And on top of that, Congress just moved toward making suppressors less restricted, not more. Through that big federal package a lot of us know as the One Big Beautiful Bill Act, which cuts the tax and red tape around suppressors. So at the exact moment the federal government is stepping back, California is dug in on a total ban. That clash, federal permission versus state felony, is the spark for this entire lawsuit. The district court, the first stop in the federal system, basically looked at all of that and shrugged. The judge said, in essence, a suppressor is not a weapon. It doesn't shoot anything. It's not armor. It's just an accessory. Because of that, it's not an arm in the sense the Second Amendment protects. That's how they tried to dodge the modern test the Supreme Court set up. If you remember the rule from Bruen, the court is supposed to ask 2 questions. Does the plain text of the Second Amendment cover the person and the conduct? And if it does, is there a historical tradition of this kind of restriction? The district court tried to stop at step 1 by saying, no, silencers aren't covered at all, so we never even get to history. That's how Sanchez ended up appealing to the Ninth Circuit. So what happened when this thing finally hit the 3-judge panel on November 18, 2025? Inside that courtroom in Pasadena, you had 2 very different performances. On one side, the lawyer for California leaned hard into this idea that suppressors are nothing but optional add-ons. He told the judges, in so many words, that silencers are rare in crime but can still be banned because they supposedly add some super added danger when a criminal uses one. At the same time, he argued they don't count as protected arms, so the court should treat them like any other piece of gear the state wants to get rid of. Here's where it gets really important. The state's lawyer openly admitted that suppressors are rarely used in crime. You don't hear that in the headlines, but instead of saying, "Okay, then maybe this isn't a big public safety threat," he pivoted and said, "Well, they're still dangerous enough that we can ban all of them." And to justify that, he reached back to another big case out of this same circuit. Duncan v. Bonta, where the court allowed California to ban so-called large-capacity magazines. In that case, the court described magazines as basically optional parts that the state could single out and restrict. If you're hearing a pattern, you're not wrong. The move here is always the same call. The thing an accessory. Argue it's not at the core of the right, and then say the state gets to do almost whatever it wants in the name of safety. The problem is that this mindset starts to resemble the old balancing test that the Supreme Court specifically rejected. Instead of asking, is there a historical tradition of this kind of ban, the state wants the Ninth Circuit to weigh its speculative safety concerns against your rights and just defer to the government. That's exactly what Bruen told lower courts not to do. On the other side of the podium, the attorney for Sanchez showed up ready to fight under the rules the Supreme Court actually laid down. His first point was simple but powerful. The arm here is not some floating metal tube sitting on a table. The arm is the firearm configured with a suppressor, and that is plainly a modern weapon used for lawful self-defense. When you look at it that way, the plain text of the Second Amendment absolutely covers the conduct. You're a law-abiding citizen, you're keeping and bearing a firearm for defense, and you're choosing to do it in a way that reduces noise and blast. From there, he pushed the court to do what Bruen requires: walk through the history. Is there any real American tradition of banning an entire category of devices that make shooting safer and more controlled for the law-abiding? Not regulating, not taxing, but outright banning. That's a very different question from asking whether a state can pass neutral safety rules. And it's a question where California comes up empty. There simply isn't a historical pattern where government said, "You can have the gun, but we're going to criminalize the things that stop you from blowing your eardrums out or disturbing the neighbors." He also made a point that resonates with anybody who has actually shot with a suppressor. These devices are not some Hollywood tool for assassins. They are hearing protection devices. They cut down the blast that can permanently damage your hearing during home defense or training. They reduce noise for people who live nearby. And in many parts of the country, they're treated as exactly that safety equipment that responsible shooters use to protect themselves and others. That's why you're seeing federal law move in the direction of reducing the tax and paperwork burden, not doubling down on bans. At this point in the argument, the judges started poking at the logic on both sides. And that's where one of the most important moments happened. One of the judges essentially said to the state, "Under your reasoning, what's to stop California from banning recoil pads?" Think about that. A recoil pad doesn't fire a bullet either. It just makes the firearm more controllable and less punishing for the shooter. If the test is, could a criminal theoretically use this, then there's almost no limit to what a state could demonize. Night sights, optics, adjustable stocks, bipods. Any of those could be portrayed as things that make a gun too effective in the wrong hands. That hypothetical wasn't a throwaway joke. It exposed the core problem with California's argument. Once you say that anything that helps the shooter is fair game for a ban, you've given the state a blank check to strip away the practical tools of responsible gun ownership. The gun itself becomes a hollow right. You might technically be allowed to own a bare-bones firearm, but everything that makes it accurate, safe, and usable under stress could be reclassified as a dangerous accessory and outlawed. That is not how a real constitutional right is supposed to work. Now, I wish I could tell you this was an easy call and that the panel clearly sided with Sanchez. The reality is more complicated. Based on years of watching the Ninth Circuit handle Second Amendment cases, a lot of us are bracing for a split decision. You've got a panel made up of judges with very different views of gun rights. Some of them have already signed on to opinions that treat arms-related cases with a lot of skepticism. So the honest assessment is this: there's a real chance we get a 2-to-1 ruling that upholds California's ban, even after a strong performance from Sanchez's side. But that's not the end of the road. If the panel rules against Sanchez, his legal team can ask the full Ninth Circuit to rehear the case en banc. That means a larger group of judges would have a chance to take another look, especially if the panel stretches or misapplies the modern Second Amendment framework. And beyond that, there is the possibility of asking the Supreme Court to step in. The justices have already laid down the basic rules in Heller, McDonald, and Bruen, but they have not yet squarely answered how far states can go in banning things they call accessories when those things obviously impact how firearms are used for self-defense. So why should somebody in Texas or Florida or Ohio care about any of this? Because bad logic travels. If California can convince the Ninth Circuit that suppressors sit outside the Second Amendment, other anti-gun states are going to copy and paste that reasoning into their own bans. Maybe it's suppressors first. Maybe it's certain optics next. Maybe it's particular stocks, triggers, or anything else they can label as extra and dangerous. Once the courts bless that playbook, every new restriction becomes, "Don't worry, we're not touching your right to have a gun. We're just outlawing the things that make it effective." That is why Sanchez versus Bonta is such a big deal. It's not just about one man and one silencer. It's about whether courts will let states use word games to carve out half of the modern shooting world from constitutional protection. In a moment when federal law is starting to recognize suppressors as normal safety tools, California is trying to lock in a felony ban and call it common sense. This case will tell us a lot about whether judges are willing to enforce the text and history of the Second Amendment, or whether they're going to keep letting states treat your rights like policy preferences that can be edited away one accessory at a time. That's where Sanchez versus Bonta leaves us a Ninth Circuit panel deciding whether suppressors are safety tools or felonies. If California wins, every accessory gets a target on it. Stay alert, stay engaged, and subscribe so you don't miss what this means for your Second Amendment rights in the future.